So in chapter 8, we're going to look at some issues that may happen in a contractual relationship. So the way we see them is like this, or the way we see this situation is like this. Well, we just learned how a valid contract is formed. So now for chapter 8, we take into consideration that a contract was formed already. And this contract seems to be valid. It seems that the 5 required elements are there. But sometimes, even though the 5 required elements are there may have happened something that causes the agreement to be either void, invalid, or voidable. Remember, voidable is a contract that is valid. However, one of the parties may cancel the agreement. The example I gave you was for capacity with minors and infants. Those contracts are voidable by the minor. So those are those are the issues that we are going to look into. And as we start them, you will picture this more clearly. So the first issue we look at is misrepresentation. What does this mean? It means a false statement. And this false statement actually persuades one of the parties to enter into the contract. Okay, simple example. You want to buy my car? We are dealing on by phone or by Craigslist. You ask me what year my car is, and I tell you my car is 2010, but actually I lied. I made a false statement. My car is actually 2009, not 2010. And you only purchased my car. Why? Because I told you it was 2010. So actually you were persuaded by my false statement. So it means you were a victim of misrepresentation. This may happen on Craigslist a lot of times. So people lie about what they're selling. And in law, there's a remedy. There's a remedy on misrepresentation. So now we know what misrepresentation is. Now we need to look at types of misrepresentation. There are 3 types: innocent, fraudulent, and negligent. So here, well, all of them, they are false statements. However, in an innocent misrepresentation, the false statement is made in a way that the person believed it was true. Let me give you an example here. You are buying my car and you ask me, how are the brakes? And I say, well, the brakes are fine. The brakes are good. I'm not a mechanic. For me, they are good. But then you buy my car, you take it to a mechanic, and the mechanic says, oh, those brakes are terrible. You should replace them. So you were a victim of a misrepresentation, however, an innocent one, because I honestly believed they were good. I was driving the car normally. So that's an innocent misrepresentation. Whereas a fraudulent misrepresentation is one in which the person actually knows they are lying. There's intention. There's knowledge about the false statement. My first example, I knew my car was 2009, but when you asked me, I told you my car was 2010. So that was a fraudulent one. And the negligent misrepresentation is the one, misrepresentation. This is the one we borrow the concepts from negligence in torts. So the person issuing the statement has a duty of care, but breaches that duty. When does a negligent misrepresentation take place? Usually takes place with experts, with companies. So let's say you go to Apple Store and you want to buy an iPad. However, you need the iPad for this online course, and you need it to for online exams. And you ask the salesperson, is the iPad good for Proctorio tool, the tool that you use for your midterm exam one? And the salesperson says, yes, it works with Proctorio, but you know it doesn't work. So the salesperson did not intentionally mislead you, but at the best of their knowledge, and they should know more, they breached their duty. They had a duty to inform you at the best of their knowledge, or precisely because you made a question. So this would be an example of a negligent misrepresentation. So I've given you examples of those three different types. But what is important here is the consequence. Whenever someone is a victim of a misrepresentation, what matters is the type, either innocent, fraudulent, or negligent, because of the remedies available. Damages, they are available only to fraudulent and negligent misrepresentation. Damages are not available for innocent misrepresentation. Victims of innocent misrepresentation, they have only rescission as a remedy. What is rescission? Rescission is to cancel the contract. You give back the product you purchased and you get back your money. That's the only remedy. But if you are a victim of a fraudulent or negligent, on the top of rescission, maybe getting the money back and giving back the product, you can still sue for damages. So let's say you purchased that iPad, but then you couldn't write your midterm exam one, and you failed the course. So you want your money back, you want to give back your iPad, but you also want damages because you failed a course and you have to pay for this course again, and time and your transcripts, etc. So on top of rescission, which is canceling the agreement, damages would be available in both situations, either negligent misrepresentation or fraudulent. But in the first example, you asked me about the brakes of my car, and I told you the brakes are just okay, just good. And then you learn later on that no, they're not good. The only remedy is rescission. If you lost an opportunity, if you had damages because you purchased my car, you cannot recover those damages. Okay? Only the money back. So that's misrepresentation. Again, the contract is valid. However, one of the parties was persuaded by this false statement. And there's a remedy, or sometimes two remedies available. Okay? So let's practice this here. Okay, so here I'm asking you to point out to me which one is a situation in which damages are not available. And I just told you, damages are not available in an innocent misrepresentation. And the only innocent misrepresentation example we have is letter A. So yes, A is the correct one. All other choices, they are either fraudulent or negligent, hence the not all other, but B, C, and also E. So those are situations in which damages are available. D as well, because there's a false statement becoming a term of the contract. Okay, so you got that well. Let's move on. Now we look at duress. Duress is a serious thing that happens to a contract, is a threat. Duress is very serious. There's a threat of violence, threat of imprisonment, threat of telling lies, false statements to others, threat of losing employment. So I am your boss. I come to you and I say, hey, I need to borrow 10,000 from you. And you say, "Well, I have the money, but I don't want to lend this to you." And I say, well, if you don't lend this money to me, I'm going to fire you. So you end up lending this money to me. This is a valid contract in principle. Why in principle? Because it looks like valid, but in the back of it, you only entered into this agreement because you were threatened to lose your job. So this is duress. This example is an example in which you were a victim of duress. And there's a remedy available. The remedy is the contract is voidable. And I'm saying here voidable, not void. What is a voidable contract? It is a valid contract in principle, but you, the victim, you may cancel the agreement in court. And I say you may cancel. And I'm not saying you have to. Maybe you decide not to cancel the agreement. Maybe I'm paying back the loan as agreed. Maybe you don't want to bother with lawyers, with legal fees, court hearing, etc., etc. And if you don't want to bother with this, let's say you are a millionaire, this 10,000 is nothing to you, the contract is still valid because it's a voidable contract. Okay? So a voidable one is a valid contract in principle, but in this case, there was duress. And the victim of duress may challenge this contract in court and have this canceled. Another situation is called undue influence. Undue influence is not so serious as duress, but it is still an issue. What is undue influence? When one party makes pressure over the other party. And this pressure is related to usually a dominant position or because the person holds trust. A good example is a social relationship. Church leader and church goer. Usually church goers, they trust their church leaders. So let's say the church leader offers an agreement with the church goer to sell their car or to borrow money. The church goer is not so happy about that agreement, but they feel this pressure. They feel that they will not be seen well, they will not be regarded well if they don't enter into that transaction. So if they want to challenge this in court later on, they could claim they were victims of undue influence. Professors and students, the same situation. Lawyers and clients, doctors and patients. So those are all situations in which there may be pressure from one party who is a dominant one and who has trust over the other. And what the law here the law aims to avoid this illegal abuse of this trust and dominant position. Okay, so not so serious as duress, but still there's an issue. The party only entered into the agreement because they felt they had to. They suffered this pressure. They had their trust abused by the other party. And another one is unconscionable transaction. So here, those are transactions that they are not reasonable at all. Those are transactions that most people would never enter into. Let me give you an example. So my mom, she's 70 years old. She's not so technology savvy. So let's say she's offered a smartphone for $10,000 and she buys it, let's say. No one would pay $10,000 for a smartphone. So this is an example of an unconscionable transaction. A transaction no regular person, no a reasonable person would enter into. Then this transaction is not void, is not illegal. However, if you bring this situation to the courts would correct this situation. So in my mom's example, she would have purchased the smartphone for 10,000. Then she would sue the seller. The court would say, well, I will keep the contract, but I will correct the amount. The correct amount for this smartphone market value is 1,000. So you have to return 9,000, the difference to the purchaser. So those are unconscionable transactions. Other example, here in Canada, interest rate is about 5%, 10, 20, but not more than this. Not more than this. And if you get a loan for 100% interest rate, you may claim you were a victim of an unconscionable transaction. Okay? That's another example for this. Are we good so far? All right, so question for you. All right, so all the options here, they are true except one. And I want this exception. I want the false one. So let's look at D. D as Donald. If you are a dominant person in relation to an aged relative who wants to sell you his house below market value, you should insist that the aged relative receive independent legal advice. D is actually a true statement. Why? Because here is an example of unconscionable transaction because there's a relative transaction. A transaction with a relative in a family relationship, undue influence is presumed. There's presumption of undue influence. So one way to avoid this presumption is to have one of the parties to seek independent legal advice. Okay, I didn't emphasize this when I was explaining, but then I'm emphasizing now. So there's presumption of undue influence in family relationships. Let's look at B. B, if the court presumes the existence of undue influence, the person asking for the return of the property will automatically get it back. Automatically here makes it false. So this is the right answer, letter B. Why? Because you don't get it automatically. Why don't you get it automatically? Because the person who is being claimed to have abused your trust, they may show evidence that they did not abuse the trust. So even though there may be presumption of undue influence, the other party may still prove they had you seek independent legal advice. They also enter into the transaction for a fair market value. So those are examples of evidence that would rebut this presumption. Because this presumption may be rebuted, we cannot say the victim will automatically get the item back. No, they may get if this presumption is not rebutted. Okay? So that's why B is the false statement. B is the right answer. Is that clear? Any questions in letters A, C, or E? No? Okay, I'll move on. If any questions show up, I'll return. All right, so let's look at mistake. Contracts may also there may also be mistakes in a contract, but this mistake, the mistake that is more important to us, is the legal mistake. We'll see that there may be situations in which there's a regular mistake. Regular mistake, I mean, let's say we agreed the sale price was 10,000, and when we were drafting the agreement, it was drafted as 100,000. But that's clearly a mistake. There's a typo there, 10 in excess, because both parties they clearly agreed, and they confirmed they agreed for 10,000, not 100,000. But here, the legal mistake is a mistake that will destroy consensus. Why destroying consensus? Well, let's remember in chapter 6, consensus is made of a valid offer. So you may remember that an offer will have terms of the offer, the price, the conditions, description of the item, etc., etc. And a person who accepts that offer will make an effective acceptance. So when there's a valid offer and effective acceptance, we say there's valid consensus. When there's a mistake, it means there was an issue with either the offer or with the acceptance. And this mistake destroys this requirement of consensus. So that is what is mostly important to us. And we'll come to some examples in a minute. But first of all, some concepts we should know. The first one is when we are negligent, we cannot say this was a mistake. What is to be negligent? We are negligent when we do not exercise due care. So let me give you an example. I am buying something and I am not asking any questions. I go to Apple Store to buy an iPad, but I don't ask any questions to the salesperson. I just say, I wanna have this iPad. Maybe I am negligent because I didn't check if the iPad was working properly or if the iPad would work for my need, etc., etc. So if I don't make questions, if I make the decision my own, and I make a mistake myself, I am negligent. This is not a mistake in law. In other words, the courts, they will not help. They will not do anything. Okay? So we have to be diligent when we are entering into contracts. And we also have here the rectification. So rectification is to correct. To rectify is to correct. A simple example here, the one I gave you. We agreed on 10,000, but when the contract was drafted, it was drafted as 100,000. So that was a typo. In this case, courts, they would correct the agreement if needed be. But in most cases, courts, they don't like to rewrite the agreement. Courts, they will either say this understanding is the valid one as opposed to this other one, or they will say no, there's an issue here, so the contract is void, the contract is invalid. Courts will rarely rewrite, will rarely add their own interpretation to a contract because they are respecting the freedom to contract of the parties. But when there's an obvious mistake, obvious error, as this 10,000, 100,000, then they would correct. Okay? Shared mistake is one of the most important legal mistakes we need to know. What is a shared mistake? Shared mistake it is when both parties of the agreement, they make the same mistake. And this same mistake is related to the object of the contract. This is a fundamental mistake, as it is saying there. So let me give you an example. And this takes place when they are entering into the agreement. So let me give you this example. We meet at BCAT and I'm selling my car to you. So we agree upon this sale. But unknown to you, unknown to me, my car was stolen at the parking lot. Or my car was destroyed, caught fire. Something happened. So both parties, you and I, we made the same mistake. We thought we were dealing with a car that actually doesn't exist anymore because it was either stolen, destroyed, or whatever it was. And the car was the object of the agreement. So in law, this is a shared mistake. It means there's no contract. We thought there was a contract, but because the object doesn't exist, there's no contract. If you gave me your check, if you e-transferred your money, I have to return this to you because there was no contract. There was a shared mistake. Okay? So this happens while we are forming the agreement. Misunderstanding. Misunderstanding is also related to a mistake, but it is when one party understands one way, the other party understands in a different way. The same word, the same expression, the same section, the same clause. Let me give you this example. Two companies enter into an agreement, and in one part of the agreement it reads place of business. So one party understands that it is their place of business. The other party understands that it is their own place of business. So this is an example of a misunderstanding. The same term, the same expression is understood differently by the contracting parties. So when this issue happens, the remedy is the courts, they will apply the reasonable person test. What is the reasonable person test? Well, what would a reasonable person interpret? How would a reasonable person interpret this expression, this word? Would they interpret based on the circumstances, based on the contract as a whole? Does place of business mean A's place of business or B's place of business? So courts would apply the reasonable person test. However, if in a situation both parties' interpretations are correct, courts would then declare the contract as void, as null, as inexistent. Why? Well, because if the understanding is different and both of them are valid, so it means there was an issue in consensus. There was an issue in either the offer or the acceptance, because parties understood that differently. Okay? So when there's a misunderstanding, courts will apply the reasonable person test. And whatever that reasonable person's interpretation is, they will apply it. In an event, both interpretations are reasonable, are valid, then the contract is void. The contract is null. Okay? So one-sided mistake is very simple. This is when we make a mistake ourselves. I've given you the example already. I'll repeat that one. So before you start this course, you thought that an iPad would be okay to write exams. You go to Apple Store, you don't make any questions, you don't ask anyone, you just say, hey, give me an iPad. So you make the mistake yourself because you believed it would work for Proctorio, but it doesn't. You did not receive any consultation, any words from the salesperson. You did it yourself. So in this case, one-sided mistake, the courts, they don't help. Courts are not worried about those because you made a mistake. So you have to bear the consequences. Let me give you another example. So you go to Home Depot and you buy 2 gallons of paint because you want to have the walls of your bedroom painted. But then after you have them painted, you learn that you only needed 1 gallon, not 2. But you made the mistake yourself. You thought you needed 2. So it means you cannot sue Home Depot to return 1 gallon extra you have because you made a mistake. It is different if you go to Home Depot and you say, hey, salesperson, come here, please help me. My room is this size, is measured like this, is let's say 100 square feet. How much paint do I need? If the salesperson tells you you need 2 gallons and you end up only in need of 1, what happened in this case? Tell me in the chat, please. So the salesperson advised you in a wrong way. What is this? We just learned in this chapter, in the beginning of the... Yes, that's misrepresentation. That's a false statement. And yes, it is a negligent one because the salesperson didn't do this intentionally. They did this at the best of their knowledge, but they made a mistake. So it is negligent misrepresentation. In the second example, you could sue Home Depot to return 1 gallon. But in the first one, the one that you went there, you purchased those 2 gallons, you didn't ask anyone, so you made the mistake yourself. This is one-sided mistake, and courts, they don't help. Okay? And we have no satisfaction guarantee either. What does this mean? It means, let's say you buy something and you don't like it, you're not happy. You have no legal right to return. I know you may be thinking, well, this is not true for Apple, this is not true for Home Depot, this is not true for Walmart or many stores you are thinking about. Well, let me tell you, you have no legal rights to return. But companies, they offer you the possibility to return. 7 days, 30 days, 90 days. If companies offer, then you have the right. But this is not a legal right. This is a marketing strategy the company is using. The company is saying, hey, come here, buy whatever you want. As long as you have the receipt, as long as you have the original packaging, you can return up to 7 days, 30 days, 90 days. So let us not confuse this with the legal right of satisfaction. There's no such a right in law. Okay? What companies do? They offer you this as a marketing strategy, as a way to attract more clients. All right, so known as factum, this is a Latin expression, and the meaning of this Latin expression in English is "it's not my act." This is actually not an issue in contract. This is a defense. In case you are sued, you could use this non est factum as a defense. But this defense, as I have there, is rarely successful. Rarely successful. Why? Well, first of all, what is this defense? This defense is when you are claiming that what you did not mean what you did. And this is related to a document. So let's say you signed a check, but you didn't mean to sign the check. Well, how come you sign a check and you didn't mean to sign it? That's why this defense is not successful. Because in most cases, you are actually negligent. You are not diligent. But let me try to give you an example in which you could use this defense. So let's say you go to your bank, to a bank. You want to open your banking account, checking and savings account, and then after you negotiate everything, the bank manager prints a lot of documents for you to sign. And we usually we don't read those documents. We just sign. The bank manager just says, hey, you sign here, you initial here, sign there, etc., etc. So let's say you were diligent, you read them all, but the bank manager was so smart that on the top of making you signing all the agreements, the manager also made you sign a loan agreement, but you are not there to get a loan. The bank manager was smart, and on your side, you were diligent, but you are not very familiar with those financial agreements. So you didn't know you were signing a loan agreement as well. So if this is the case, and it's just created scenario here. So if you were sued because of that loan, as your defense, you could claim non-est factum. No, it was not my act. I went there to start to open a banking account, and I was clear. And there's recording, and there's this, and there's that. Well, it's a lawsuit, but still, you were diligent. But still, you signed something you didn't mean. You signed a document that was different from what you wanted to sign. Okay? This is not common. In most cases, this defense will not be successful, but I just tried to give you an example in which you can understand this a bit more clearly. Okay? All right, so question for you to practice. Okay, so we have D and E, eventually E, oh, eventually, sorry, A and E, not D. So E, let's look at E. So the couple, Houston, they were selling their property, and Sam did not speak to anyone. Sam offered to close the transaction because he thought, remember, he did not ask anyone. He thought it was suitable for growing wheat. And after the offer was accepted, so once the offer is accepted, the agreement is entered to, he learned the land or property was not suitable for wheat. Is this a shared mistake or one-sided mistake? What do you think? Sam thought himself. So it's one-sided mistake. Yes, that's correct. One-sided mistake, a contract is legal. So Sam will have to go ahead with the deal. Courts will not help the one-sided mistake. Okay? So this is not the right answer. Why? Because it's one-sided mistake. A contract in which a mistake will make it void is a contract with a shared mistake. And shared mistake, A. So two parties, they contract for a shipload of coal. Unknown to them, remember my car example to you. Unknown to them, the ship had sunk and the coal had been lost. So this is a shared mistake. Here the contract is void. Okay? So A is the right answer. B, what is B saying? So Sally and Waki had a serious misunderstanding. Okay, so misunderstanding is a type of mistake, but not a mistake itself. About a term, the court found the more reasonable interpretation was Sally's. Well, if Sally's was the more reasonable interpretation, then Sally's interpretation will be applied, and the contract is still valid. So B is not the correct answer because of this. If Sally's interpretation was more reasonable, then this is the interpretation that will be applied and the contract is valid. So A is the right answer. Is this clear? Yeah, so in B, the misunderstanding was solved by the court. In C, there was a typo. So with typos, courts, they correct, and the contract is still valid. D, one-sided mistake as well. D and E, there's one-sided mistake. So E, I explained it already, but D, Sam bought 3 gallons of paint, found he made a mistake. He made a mistake. It was not the salesman that caused him to make a mistake. He made a mistake himself. So here, one-sided mistake as well. Contract is still valid. All right, moving on. So, rules of interpretation. Reasonable person test, we've seen this already. We just reviewed this here in this question. So courts will always, whenever possible, they will apply the reasonable person test. But if this test is not enough, courts may also look at the meanings of the words, expressions, sentences, etc. Parallel evidence rule. So you should know this rule. Why? Because the parallel evidence rule says that when a contract is in writing, courts, they will not accept external evidence. So if a contract is in writing, courts will not accept recordings, videos, witnesses. They will only interpret the contract, either by applying literal or liberal meanings or the reasonable person test, or they will cancel the contract. But they will not accept outside evidence. This is what the parallel evidence rule means. And again, this just emphasizes that courts, they don't like to rewrite contracts. Courts, they try to keep the contract the way it was agreed by the parties. Okay? Privity of contract, an important concept. What is this? Privity of contract is so simple that sometimes people get confused, but it's simple. Well, a contract only affects the parties to the contract. This is what privity of contract means. Let me give you these examples. So you go to Starbucks now and you buy coffee, but they, instead of giving you coffee, they give you tea. Well, there's an issue with the contract. Yes, there is. But who is affected by that contract? Only you and Starbucks. No one else. The person behind you, the other people, they were not affected by your contract and Starbucks. Another another example. So you buy an airline ticket. Who is affected by that contract? Only you and the airline company. No one else. So that's what privity of contract says. Only the people to a contract is affected by that contract. Okay? Very simple, very straightforward. However, what is most important here with privity of contract are the exceptions. The exceptions to this rule. And let me give you the two most important exceptions. First one, when a person that is outside the contract that can enforce that contract. This is very common with life insurance. So you may agree with me that the person who buys life insurance, they will not get the coverage. The one who will get the coverage will be the beneficiary, because the life insurance is only paid out when the person who purchased it died, passes away. So in a life insurance contract, for example, we have an exception for privity of contract, because the person had a life insurance and they died. For whatever reasons, legal or illegal, the insurance company, they don't want to pay the coverage to the beneficiaries. But in this case, the beneficiaries, they can sue the insurance company. Even though they were not party of the contract, they were outside party, but they can enforce the contract. So that's an example of an exception here. There's another exception that is very important. Rights in a contract related to land. So it reads there, contractual rights, they run with the land. Well, my example here is, if you are a tenant, if you rent your house, and your landlord, they decide to sell the house. I'm telling you that contractual rights, they run with the land. So what I'm saying is that even though your landlord sells the house you are renting, you are still renting the property. So the buyer, they have to respect your tenancy agreement. The buyer actually becomes your new landlord. So in real life, if you are a tenant, you should be okay. You know that your agreement is still valid. And if you are a landlord, not a landlord, sorry, if you are the buyer of a house and you want to live in a house, in the house you are buying, what you need to do in your diligence process, yes, you need to search if there are any contractual rights with that land, with that house. Because if there are any, you, the buyer, you are bound by them. Okay? So contractual rights, they run with the land. So they are exception to privity of contract content. This is novation. I will talk more about novation next week in chapter 9. Okay? So the last part here, if I'm not mistaken, is assignment. Yes. What is assignment? Well, assignment is related to a contract. Assignment is when one of the parties of a contract assigns a benefit they have to a third party. So let's say I am a gardener, and I was hired to do the garden of a house. So there's a contract, service contract, and I did the garden this afternoon. But payment will only come in 1 week. We agreed that payment would be made in 1 week. So now I have complied with my obligation and I have a benefit. I have the payment to receive in 1 week. But let's say I need the money tomorrow. And my neighbor is rich. They can wait until next week to get this money. So I can transfer the benefit of payment to my neighbor, and my neighbor can advance the money to me. So this is assignment, when I am assigning a benefit I have in a contract. Because obligations, they cannot be assigned, but benefits can. Companies, they do this on a regular basis. Companies, they sell products or services on a 30-day term, 60-day term, 180 days term. but they need money before. They need money for raw materials, for salaries, for taxes. So they assign their benefits to banks, to financial institutions, and then those financial institutions will charge them processing fees and interest rate, but then they advance the money to the companies. And the financial institutions will be the ones getting the payment at that date. So that's what assignment is. And most of assignments, here you have the visualization, but most of assignments, they are the statutory assignments. What is a statutory assignment? Well, statutory comes from statute, comes from law, from act. A statutory assignment is the one that is in the law. And all assignments will be statutory if they are absolute, unconditional, if they are in writing, and if proper notice to the debtor is given. What is proper notice to the debtor? Well, in my example, as a gardener, I assign my payment benefit to my neighbor. I told you my neighbor is rich. So before assigning the benefit to my neighbor, I would need to give notice to the debtor, to the person who hired my services, my gardening services. Hey, I'm assigning my payment benefit to my neighbor. This is to give proper notice to the debtor. So if I complete all those requirements, this is a statutory assignment. The consequence of this is that if the person who hired my gardening services doesn't pay my neighbor can sue them directly. My neighbor doesn't need to sue them on my behalf because I have assigned, and because this assignment is statutory, I have nothing to do anymore. I have nothing to do with this transaction anymore. Okay, so that's the real consequence for statutory assignment. Okay, let me get a question here. So if the benefit has been transferred and is not able to collect, then does it go back to the seller? No. So if the benefit, let me just see how to explain this. So my company sold products to company B, and then I assigned my benefit of payment to a bank. And then if the bank is not able to collect from my client, from my purchaser, does it come back to me? No, it doesn't come back to me. The bank will be the one suing my client. Okay? Because they are now the ones with the rights over that benefit. And that's the main purpose of the statutory assignment. All right, so that is clear. There are things that cannot be assigned, such as support payments, workers' compensation benefits. So the law prohibits those to be assigned. Okay, that's the law. This is you have to know this. Involuntary assignment, what is this? This is when the assignment is automatic. Well, how come an assignment can be automatic? I'll tell you. It is automatic when someone dies. When someone dies, their assets, their estate will be passed to the executor or administrator, state administrator. So this is involuntary assignment. Or in case of bankruptcy, we'll see bankruptcy in chapter 15. But when a company or a person is bankrupt, all their remaining assets, if any, they are automatically transferred to the trustee in bankruptcy. Okay? There's a question here. With an assignment, does the other party need to be notified that the benefit is going to another party? Yes, if it is a statutory assignment, and most assignments are statutory. So yes, proper notice has to be given to the debtor, the one that has to pay. Okay. All right. Yeah, so that's chapter 8.